Today we're going to go through the 3 certainties of a trust. Hopefully you'll have already read the subject guide on this, so I'm going to try and supplement your reading, give you some information, point out some areas that you should be considering that are likely to come up in an essay. The important thing to note about the 3 certainties is that you need all 3 of them to make a trust, and if there's any doubt about any one of them, then it's likely that you don't have a trust at all. So that's important to remember for a problem question, is that a trust can be invalid if just one of them can't be shown, if one of them is found to be uncertain by the court. And the 3 certainties that you need to create a trust are the certainty of intention, so the intention that the settlor has to create a trust or to put the property into trust. And then you need certainty of subject matter, which is put down in the subject guide as certainty of trust property. So it's what's in the trust. Is it clear what property is meant to be held by the trust? And certainty of objects, which is also certainty of beneficiaries. So that's number 3. The reason that I'm going to use certainty of subject matter and certainty of objects is although the subject guide doesn't use it, a lot of your textbooks use those phrases instead of the certainty of the trust property and certainty of beneficiaries. So I'm going to use those terms because I think that's what you'll come across in your extra reading rather than just what's in the subject guide. So the first one we're going to do is certainty of intention. Certainty of intention is a slightly tricky one. What it means essentially is that it's got to be clear that the settlor did intend to create a trust. Now remember that the 3 certainties only really apply to express trusts and presumably to certain types of resulting trust. So you remember that diagram that I sent to you, hopefully you have it. On the one side we have the types of express trusts, and the other side we've got types of constructive trusts, and then we've got presumed resulting trusts in the express trust as per Swadling's analysis. So you need to have this intention, or in the case of a presumed resulting trust, I guess according to Swadling, the court can presume that this intention did take place. Obviously, you're not going to have this intention for a constructive trust, and these certainties don't apply to a constructive trust. But it's the intention the settlor has to give away property. Now, it may be that in some cases you could argue the settlor doesn't mean to create a trust, in the sense that they may not know what a trust is. And if they don't use the word trust, that doesn't necessarily mean that they haven't created it or that they don't have sufficient intention, but they have to have the intention to give away the property, or to give away rights in the property that then create a trust. So they may know that they're just giving away the beneficial interest and maybe putting the legal interest elsewhere, or they may not quite intend that. Maybe they give it to a child and the beneficial interest is held by the child until they're 18, but the legal interest is going to be held by their parent or guardian until they turn 18. The settlor may not intend that, but they intend to give away the property so that the beneficial interest does vest with the child. So just remember, you don't have to use the word trust. In real life, yes, they probably would. In a problem question, not necessarily. So you need to be looking at what is the intention of the settlor, and that needs to be the main question in your mind if you've got a problem question dealing with the 3 certainties. You may also have an essay question. I think the essay question would probably go towards certainty of subject matter or certainty of objects, but not necessarily. There may be one on certainty of intention, so you need to be thinking about that, and it's a good area to really get to know the case law. The intention of the settlor is a tricky one. One of the oldest cases is Jones and Locke, where you'll have read about it. The father has the baby, writes a check, doesn't sign the check, or complete it. So it's not enough for somebody, if you've got a check, somebody has to be able to fill out all the requisite forms, take it to the bank and say, this person gave me this check, therefore credit my account with £100 or whatever it was. So he writes the check, he doesn't sign it, he says, I give this to baby for himself, and then he dies a couple of weeks later. Baby's left nothing because most of it, or all of it, I think in the case, went to the children of his first family. So obviously the guardians of the baby wanted baby to have a trust of the money, because that would be all that was left of his inheritance. But the court decided no, it wasn't enough. And you need to look at what happened here. Why wasn't it enough when the father had said the words, I want to give this to my child, and then the court says it's not good enough. It doesn't create a trust of the money that this check represented. The problem is that he didn't mean to create a trust. The court found that really he wanted to give a gift. Now, equity can perfect imperfect gifts. It can say this gift was not given properly, and therefore we're going to say it should be completed, it should be given properly. You see this in a lot of promissory estoppel, but that wasn't what happened in Jones and Locke. Equity isn't necessarily, it's not going to create a trust if the trust wasn't intended. It may give a gift if the gift was intended and wasn't properly created. But equity doesn't interfere if you haven't given trust property away, or it shouldn't, was the principle in Jones and Locke. And it wasn't going to interfere if the father had just mistakenly not given the check over properly to his son. I think it was a son, the baby. Because if you think about it, just wanting to give a gift isn't enough to give the gift. If somebody says to you, I give you my wardrobe, or I will give you my wardrobe, more likely, and then never actually gives it to you, never takes it out of their house and loads it up into the car and drives it over to your house, then the wardrobe's not yours. You can't just go into the house and take it, because they've only expressed a desire. And there's more to giving a gift than expressing the desire to give the gift. You have to actually deliver it to transfer ownership by gift. Sometimes you don't necessarily have to deliver it. You probably will have done this in contracts. If you're giving a gift of land, then you might be able to give over the keys to the house on that land. And that's deemed enough to give a gift. But normally you do have to give it over or transfer possession or do something more than just say, I give this to you. Because it might be an immoral thing to not give a gift where you've promised to give a gift, but it is not something the law concerns itself with. And that's what happened in Jones and Locke. It was unfortunate, but the father didn't mean to give a gift of the didn't mean to create a trust of the money. He probably intended to give a gift of the money, but there wasn't anything like promissory estoppel going on in this case, and so the gift of the check just didn't work because he didn't sign the check and it wasn't completed. So you need to just think about if you've got a problem question, what is the intention that the settlers got here? Do they mean to create a trust? Do they mean to give a gift? If they mean to give a gift, does it create a trust? Probably not. But do read up the case law, and what I suggest you do is write out all of the cases that are mentioned in the subject guide, go looking for them in the textbook, and basically write a sentence or two about what exactly they say about what the requisite intention is. Because like I said, this is a really good essay question. It's often a very good problem question, and it is one where you need to be looking at the case law. So go through all of the intention ones. I suggest writing out a sentence so that you really understand, and if they contradict each other slightly, that's probably right. A lot of these cases, they're not entirely consistent. You have to look for the consistencies or the inconsistencies and argue them, but that's why it's probably going to be the subject of an essay question.